Okay, recording. Welcome to the 4 o'clock tutorial on week 10 and a half, as I'll call it, because we're going to be traversing what we're doing between weeks 10 and 11. Today, I will go through the TEO Act with you. Who's watched the lecture or listened to the lecture? Desmond, Neil? Good.
Yes.
All right.
Yes,
Now, Nikki's written me a long and torturous email, which I'm halfway through answering. But I think it's a good idea to write questions on the Moodle, because then I can answer it for everyone. Nikki, do you mind if I put your email on the Moodle, if I answer those questions on the Moodle, or do you feel like I won't say this?
No, that's fine. I should have done that, but that's fine.
No, that's all right, because they're probably questions that, I mean, they're very intelligent questions, and they're probably questions that everyone has, and I'm putting a fair bit of effort into answering them so that it's there for the benefit of everyone. All right, well, look, I went through on the lecture the TEO Act, and I'm not sure that I need to go through it in huge detail, except to I probably went through it to the extent to which I would in the tutorial. So I'm not going to make this tutorial about the provisions, but what I thought we could do was discuss some of the matters that I raised as potentially problematic in the lecture. And are you prepared to come off mic, or are you just going to send lots of chat messages that I can't keep up with? And don't be ironic now. You can come off mic and answer that instead of, yeah, rugby starts at 5:45. Yeah, we're not going beyond an hour and a half. I've got to make nachos for dinner. Okay. All right. So look, I thought the first question that I will that I raised in the lecture is definitions. Have you had an opportunity to look at the criminal code? You can go through Mike Wing. It's all right. I'm being stupid. All right, so the criminal code's up, and you've seen how dense the provisions are. And so what I'm going to say to you is have a really good look at those, because of course the question in the exam is going to require you to engage with those provisions, and you're going to need to understand, you know, how to construe them, because that section of subsection 10 subsection 10 subsection 2 is a very dense provision. The proscription, as I call it, on the power. I mean, if you're not allowed to exercise the discretion unless those things exist, then that would be where you'd be putting a fair amount of time and effort into trying to discern whether or not those things exist. So that's the first point I'll make. Definitely go through the definitions as they are to be found in the criminal code and work through those. I might have a quick look at them now with you, because I think you'll benefit. I'm on my laptop. Hey, let me just plug in the rest of my crap, because then I can look at your chat as well. Just give me 1 second.
But are we only interested in the criminal code to the extent of the definitions? So the definitions of a terrorist organisation and that sort of thing. There's nothing else. There's nothing else about the criminal code that we're specifically concerned about. No, there's not. But our police prosecutors raised a very good point the other day, which I have to say hadn't occurred to me, and that was, well, by virtue of the fact that the criminal code provides the relevant definitions, what else are we importing with those definitions? So that's why I want to raise it, because just a sec. I want to be able to see your chat. Okay, I'm up. All right, so in the legislation for the exam folder, everyone, if you're not there, go to the Criminal Code Part 5.3, have a look at that.
I suggest you print all of this out, and if you can't print it off the Moodle, go and find it yourself in real life on legislation.gov.au and use it from there. So the definition section is 100.1, and it defines terrorist act means, and this is a really, it's quite a dense provision, means an action or threat of action where the action falls within subsection 2 and does not fall within subsection 3. So you have to work your way through it. B, the act is done or the threat is made with the intention of advancing a political, religious or ideological cause, and the action is done or the threat is made with the intention of coercing or influencing by intimidation the government of the Commonwealth or a state, territory or foreign country, or part of a state, territory or foreign country, or intimidating the public or a section of the public. So that is a cumulative provision, and it, you know, you have to have each and every one of them present. That's the first point to note. Obviously, subsection C or subparagraph C, you can have one or the other, but just breaking it down. So the action means that you have to identify the action or the threat of action, and the action is done with the intention of advancing a political, religious or ideological cause. Now, intention in criminal law, you know, this mental element, you query to what extent the minister can be reasonably satisfied of something along those lines. So the minister has to be reasonably satisfied of a terrorist act. So the fact that somebody holds an intention, right, how can the minister see into someone's mind necessarily? So say, for example, you know, they may not be doing it with the relevant intention as is required for the criminal law. What's the state of satisfaction that the minister requires? That's an interesting question. What else? Hang on. Are you all writing chats to me, because I have to quit Outlook? I'm just trying to pull you all up. There you are. Pull this down here. Okay. Peter's asked a question. Can you clarify my current thinking on jurisdictional error? Is it correct Craig grounds and those added subsequent other considerations in arriving at decisions regarding whether an error has occurred? Yes. They'd be your main ones. I mean, the best place to go and have a look at what your jurisdictional error grounds are is probably the ADJR Act, because they tried to codify them as best they could. Now, would the intention be a standard for criminal law, mens rea? Well, look, that's what I'm querying. I mean, that's why I'm raising it with you to think about. I don't know what the answer is. And as I said in the outline, for the purposes of, you know, jurisdictional error or statutory interpretation rather, you know, reasonable minds may differ, and the only people who are going to be able to decide this are the High Court, and they're the ones who'll decide it definitively. But it's something for you to think about. I'm not going to answer the question for you. I think you need to apply your minds to it and, you know, demonstrate that application in the exam, because I mean, of course, this is going to be relevant. There's going to have to be a terrorist act or something to that effect. The other one is, if you look at subsections 2 and subsections 3, this is action falls within this subsection if it causes serious harm, that's physical harm to a person, causes serious damage, causes a person's death, etc., etc., etc. Seriously interferes with, seriously disrupts or destroys an electronic system. That's an interesting one. And then it can't be, let's go back and have a look. It has to fall within 2, but does not fall within 3. 3 says action falls within this subsection if it is advocacy, protest, dissent, or industrial action. and is not intended to cause serious harm, that is physical harm to a person, or to cause a person's death, or to endanger the life of a person, or to create a serious risk. So see, A is advocacy, protest, dissent, or industrial action. But if through this advocacy, protest, dissent, or industrial action, you intend to cause serious harm or cause a person's death or endanger the life of a person or create a serious risk to the health or safety of the public or a section of the public, then the consideration in 3A falls away. So it's a very, as you can see, just by me having taken you to it, it's very, very dense. So work your way through it and give some thought to it. Okay. So I don't know the answer to Margaret's question, who asked, would the intention be the standard for criminal law, i.e. mens rea? I don't know. It's an interesting question. It's only something that's really occurred to me in preparing for the lecture and for today, is that this notion of intention. Because if you go back to section 10, subsection 2 of the TO Act, let me just move this over here. I'm just scrolling down. Give me 1 second. The minister must, this is subsection 2, the minister must not make a temporary exclusion order in relation to a person unless either, and remember this is the proscription on power, so it prohibits the exercise of the discretion, which is enlivened by virtue of the matters in 1A, B, C and D. But the minister has to suspect on reasonable grounds that making the order would substantially assist in one or more of the following. Okay, preventing a terrorist act. So, I mean, he's actually, he has to sort of, a terrorist act has a mental element in it. So this person, I suppose, has to unequivocally demonstrate their intention to do something. But it's funny, isn't it, that they don't define a terrorist act. Why I think this was so controversial, and one way in which they could have made it less controversial is just to adopt the terrorist act definition, terrorist organisation definition of the criminal code, and plant it in the act, itself, rather than referring back to the criminal code. Because I can't remember if it was Emma or Cherie, it was one of you two girls, who was saying, who was importing notions from criminal practice into this, and I suppose you're going to have to give a lot of thought to it before I will give some more thought to it and make some suggestions as to cases and things that might assist you in sort of unpicking this. But that's my first point. Now, I just want to go back and see. So I've just got Neil here. Anyone ask another question? No. All right. Now, the next thing that I thought you might want to give some thought to is something that Nikki raised today in her question, and I'll put the answer up on the Moodle. She said, when you in your problem question for next week, when you are applying for a return order, do you assume that the reviewing authority in that Kamal Yusuf question has actually conducted the review and had no issue with the minister's decision? And my answer to that question is well, there's a presumption of regularity in everything that is done in administrative law. So the presumption of regularity is that people who are conferred with power exercise it lawfully. That's the presumption, but it can be rebutted. And what you would do in real life is if you were defending Mr. Yusuf, and I mean, it's not really available to you to do in the problem question, but you would subpoena all of the material. So you'd subpoena all the documents, you'd subpoena the reviewing authorities' material, because that's where the minister's reasons lie. And you may find there's been a mistake. I mean, as I've probably told you anecdotally in a couple of cases, people don't realise they've made mistakes until people start poking about in the historical aspect of their reasoning or the historical aspect of their decision-making process. So that's another point. Then another thing that Nikki's raised is see in subsection 5 that where you've got all of the improper exercise of power articulation. Does this occasion a res judicata because they're the same sort of grounds that are available on judicial review? Well, the answer to that question is no, because this is just another form of administrative review, and the res judicata only comes from a judgment of a court. So this is very plainly, and I sort of was talking about this in the tutorials earlier this week, this is very plainly a form of administrative review. So in the lecture I gave a couple of weeks ago, I was talking about Ruddock and how the privative clause in the Migration Act came about, which was the entree into plaintiff S157. All of the politic behind the introduction of the privative clause into the Migration Act was there are so many levels of administrative review along the way, and we just want to shut down judicial review. And the High Court said, well, tough, you can't do it, even on Long Hickman principles. But this is just a form of administrative review. So it's like saying once a decision is made, you have an entitlement to go to a review authority, but rather than there being an entitlement, because you have no knowledge of the decision being made, it automatically gets reviewed whether you like it or not. I mean, I think most people would like it, but it automatically gets reviewed by way of Section 14 reviewing authority procedure. Now, Orsuf's asked the question, is there any further readings for sections 2 and 3 of the Criminal Code? When you say sections 2 and 3 of the Criminal Code, are you saying subsections 2 and 3 of section 100.1? I mean, it's fairly straightforward, Orsuf. I think you would just give them their plain and ordinary meaning. There's no magic to it. Advocacy, protest, dissent, or industrial action. I mean, clearly that's just say you are a dissentient of the government. That doesn't make you a terrorist. But if you're a dissentient of the government with the intention of causing harm, or causing someone's death or endangering the life of the person or creating a serious risk to the health or safety of the public, then you may be in a terrorist category. I don't think there's any magic to it. There's no real readings, but it'd be interesting. I have never seen in my time in practice an administrative decision that incorporates, by way of a reasonable suspicion, an actual finding, a finding of fact, because I think that, this is what everyone was complaining about. They were saying, oh, Dutton's effectively finding that someone's committed a terrorist act. Well, he's not actually. He's just forming a reasonable suspicion that they have committed a terrorist act. And I think the way it's going to be read down is that it just simply has to be in his view. And then there's a reviewing authority, but you query how the reviewing authority can be satisfied in circumstances where there's a finding of someone having committed a terrorist act, but then there's no evidence of their intention. And I'm just looking at subsection 5. The minister took an irrelevant consideration. There is a not an abuse of power. I thought.
Bridie.
Yeah.
You just mentioned about Dutton before, but the thing is that this is pretty much the police force, insofar as we have you're guilty and you've got to prove that you're not guilty. And in this case, Dutton in these wordings have actually said, that the way it's going is this presumption already that the person's already guilty, and you've got to try and prove that you are guilty of being breaching the criminal code. Because a lot of this stuff in the criminal code is things that you would have in union marches and things like that have happened in years gone by. A lot of these stuff is all sort of said.
Oh, absolutely, yeah.
We're not going to go out there and fight somebody, but if the police come in there with batons flying, of course, then all of a sudden they're going to give them a smack around the ear hole.
Yeah, but you know that they're going to construe it that if you're engaging in protest that occasions a breach of the peace, then you've committed a breach of the peace as opposed to a terrorist act. The court will construe, they're not going to construe just a plain old breach of the peace as a terrorist act. It has to be political violence with the intention of killing somebody, and that's the point. That's why intention is so important, because you and I will go out there and protest against, I don't know, whatever we're protesting against, but something, back in the day, as you say, unions or shutting down the docks or something like that, we would have protested against that, sorry. But we weren't going out with the intention of killing anyone or a sector of society or something like that. And it's proving that intention that takes it to a terrorist act, and that's why this is an interesting provision. But I thought there was and I think they've left it out actually, because the reviewing authority in subsection 4 reviews the TEO decision and decides whether or not, in their opinion of the reviewing authority, one or more of the following subparagraphs apply to the TEO decision: that the making of the decision was an improper exercise of power, which takes you down to subsection 5, was induced or affected by fraud. This is the section I was thinking of. If the temporary exclusion order was made on the basis of 10.2a, which is the one we're talking about, there was no material before the minister from which the minister could form the state of mind required by that paragraph. Now, strictly construed, there's no way he's going to be able to find the intention of most people. But
that's part of the problem.
Oh, absolutely, absolutely. And I'm just wondering how the High Court's going to construe it when people start challenging it. So is Cherie or anyone on the yeah, Cherie, why don't you pipe up now and tell us what you think about this?
I think Emma was the one that suggested it when we were talking about it.
Here, Emma, pipe up.
Yeah, I obviously work for the government, so I have a very different view on a lot of the opinions that have been voiced. But no, the onus is always on the agency that's bringing the person to trial to prove their case. So the onus is on the government to prove intention. But what I was thinking earlier is you miss recklessly. So while it states that they must have the intention to cause harm, you can prove that by reckless conduct.
Yeah, I think the example I was giving in the earlier I think I even gave it in the lecture. If someone's running around beheading people and saying, this is we'll do this to all Gentiles or Australians or all people in the US or whatever, then that sort of behaviour would suggest an intention to continue in that vein. But see, what they've been doing is a lot of these kids are over there fighting with ISIS. They're fighting. They're ISIS fighters, so they were Islamic State fighters. But how I suppose you just have to construe the Islamic State as an action done or threat is made with the intention of advancing a political, religious or ideological cause. Obviously that's it. And it's done with the intention of coercing or influencing by intimidation the government of the Commonwealth or intimidating the public or a section of the public. Now, just fighting for ISIS, is that intimidating a section of the public? I mean, it's clearly not coercing or influencing by intimidation the government of the Commonwealth of a state.
Depends how many videos they've posted up as well.
Yeah, I mean, I know, it's fascinating. I know what the problem question is, and that's why I'm thinking about it.
I just take it as a multifaceted. So they're not going to do one thing that's going to cause you to act to engage the TEO Act. They're going to be doing a multiple of things. So when you look at the definition of terrorism, there's all telecommunication, financial. You're going to have pretty good intel from FedPol, essentially, that they're communicating with agencies doing X, Y, Z. Then they're going to be at this march, that march. They're going to be organising a group of people here. There's going to be multifaceted information that's coming through, not just they posted a video and it contains a hashtag, which falls into majority of the Terrorism Act definition. It's just common sense. So your breach of peace isn't going to amount to an order. You need to just have faith in the government agencies, I suppose, in today's day and age. But
But how many marches are they going to be organising over? Because these are people who are all overseas, presumably. So we're not talking about people who are already in Australia. We're talking about people who are over fighting with ISIS.
They have to be overseas under the terms of the Act, yeah.
Exactly. So I'm just wondering, how many marches are they doing overseas that we're
going
to...
They wouldn't be doing any marches overseas. But the thing is they are... why it strains... This is what I was saying. I don't understand why they've referred it back. They've caused themselves so much trouble by referring it to the criminal code because this is effectively an administrative act. It's done without any procedural fairness. You don't have an opportunity to determine, in order to be able to construe intention, you're going to have such strength of evidence so that it just can be, it would be implausible to find any other for there to be any other outcome because of the reviewing authority being in a position where they can find that a decision was unreasonable. Plus, the other point that you need to flag in your minds is that the minister is entitled to withhold some of the information on the basis that it's not in the public interest to release it to the reviewing authority. So if somebody is out there doing precisely as Emma or Cherie described, I think it was Emma, described, they're not going to release it to the reviewing authority. So the reviewing authority properly should, in those circumstances, have a basis upon which subsection, whatever it was that I read out before.
4.
Yeah, was it 4? No, it was the temporary exclusion order. No, 3. B3. If the temporary exclusion order was made on the basis of 10.2a, there's no material before the minister for which the minister could form the state of mind required by that paragraph. And it's not there wasn't sufficient material, there was no material. But that's your probative evidence ground at its most proper. Like, there's no probative evidence. So that's bond. So that's ABT and bond right there, which you probably read when you were looking earlier on at the ADJR Act.
But there's a lot of presumption here that these people coming in from overseas have committed an offence. There's nothing to say that they actually have, except for what intel the AFP have got.
Well, it's in the same language as the arrest powers, for example, right? So all that a police officer has to do is form a reasonable suspicion that somebody has committed an offence. Okay, so they have to have there must be a reasonable suspicion that someone has committed an offence, and then they're arrested, and then they get put on trial effectively. But if their prosecution is like they're not found guilty, then they can go after the police with respect to unlawful, a whole variety of different things. So malicious prosecution if it's really that bad, but all of your trespass to person type things. So there's a category that doesn't exist, but people call it wrongful arrest, and the other one is false imprisonment. So in these circumstances, I don't think there's no false imprisonment, but I suppose there may be a new tort in that, you know, the minister could not have reasonably have formed this view, but query whether or not that's going to be open, because it's been the subject of a review and the reviewing authority has decided that it passes muster. So I'm just throwing up a whole lot of ideas that I want you to start thinking about.
So when you appeal the reviewing?
Well, you see, that's the thing. I don't think you would. I think when you look at the way the reviewing authority works, they just review it, and if they think it's bad, it never happened. But if they think it's fine, then it stands. So all the reviewing authority has the power to do is nullify the decision.
That's quite possible. It's got the reviewing authority is going to be stacked anyway.
Oh, no doubt, no doubt. But you know, that's called representative democracy. I don't know about that. I think it'll be too scrutinised. As you saw, Section 31 deals with parliamentary accountability, and look, if they just keep putting Dyson Hayden and Ian Callanan as the reviewing authorities, it's going to attract a lot of chagrin. So I'm sure that they'll appoint a variety of different ex-judges to review these things. But anyway, any other questions? I'm just going to read your, I don't have a microphone, rugby started. Can you clarify? I've answered that question. Okay, so Kio's asked a question. Sorry, I've missed something very basic. So Terrorist Act is not defined in the TO Act. You've got to, yes, correct. Have a look at the definition section. Yes, Emma's filled you in. Okay. Now, also said, what if the beheading is by an Australian who joins the Syrian army? So it may not be defined as a terrorist organisation. Well, let's have a look at the definition of terrorist organisation. That's in section 100. 1, isn't it? It's defined in the TEO Act, terrorist organisation. It refers back to the criminal code. Let me have a look. So terrorist organisation is defined in section 10 as 102.11. So 102.
I think it's what Desmond says underneath, but isn't it, wouldn't it be covered by a terrorist act, even if it wasn't part of...
Hang on. No, keep going. You keep talking.
Even if it wasn't part of, if he wasn't part of the Syrian army at that point, and he wasn't part of a terrorist organisation, couldn't it still be, you'd look at it as a terrorist act under the definition of a terrorist act, which is, I think, what Desmond said subsequent to Orsuf anyway. Oh,
so you've been jumping ahead. I love this chat thing. Let me just, I want to keep up with this too. Hang on. Because I have to mark your papers. 102.11. So terrorist organisation means an organisation that's directly or indirectly engaged in preparing, planning, assisting in or fostering the doing of a terrorist act, or the organisation that is specified by the regulations. Okay. And then what does Desmond say in his wisdom?
Would the act or action still be a terrorist act, even if not part of a terrorist organisation?
Well, look, terrorist organisation is defined in for the purposes of the TEO Act in subsection 2A4, preventing the provision of support or resources to an organisation that would help the organisation engage in an activity described in paragraph A of the definition of terrorist organisation. And terrorist organisation means, in the criminal code, an organisation that is directly or indirectly engaged in preparing, planning, assisting in or fostering the doing of a terrorist act. And then, yes, you're right, you go back up to the definition of terrorist act. And what has Desmond said? Would the action still be a terrorist act even if not part of a terrorist organisation? I think so, yes. Sorry, what section was that? Does anyone know what section of the TO was?
That was all answered. That was when you were talking before. That was section 4.4b3. So you can scroll down a little bit.
Okay.
And then Margaret's one, I think she was missing the beginning of the definition of Terrorist Act, which says Terrorist Act A, the action falls within subsection 2, but not within subsection 3.
Mm-hmm.
And then in answer to her one, subsection 3, the action falls within this subsection if blah, blah.
Mm-hmm.
So that's when it becomes eliminated if it falls within those. That was just Margaret's query.
Yeah. So, yes, if you're engaging in peaceful protest, you're not a terrorist. You only have to be engaging in peaceful protests with the intention of murdering somebody, effectively. Now, Margaret's asked another question. Does this mean that A, no, it has to be a dissentient act against the government in circumstances where the relevant intention in 3 exists, 3B, I think. But it's an interesting question. Terrorist organisation takes you back to Terrorist Act. Someone asked a question earlier up about, no, it was you, Emma, online, about, say, for example, they're fighting for ISIS. Who was it who asked that question? So if for example, an organisation is directly or indirectly engaged in preparing, so say you've got subsection 2A4, someone is supporting an organisation that would help the organisation engage in an activity described in A of the definition of terrorist organisation. If this organisation is directly or indirectly engaged in preparing, planning, assisting in or fostering the doing of a terrorist act, and you go back to a terrorist act and you've said ISIS and you're dealing with this question of extraterritoriality, this is my question as well. Like, you know, how just because you're fighting for ISIS doesn't necessarily mean that you're threatening the Commonwealth or a section of the public. And it must be, we can only legislate with respect to our citizens. We can't legislate extraterritorially. So the section of the public in the definition of terrorist act must be the Australian public. So the fact that you're just over fighting to create an Islamic state doesn't necessarily mean you're a terrorist, does it? You have to want to come back here and engage in jihad, I think.
Wouldn't that bring us back to looking at the intention of the act as a whole again? Because, you know, you look at what the purpose of the act is, and that's exactly that, is to protect the public in Australia.
Yeah, you'd have to want to come and be committing a terrorist act here. You'd have to be supporting a terrorist act here, something that engages the definition here. Anyway, you need to think about this because I know my question that I've drawn for you, and yeah, you'd be thinking about it. You better start now. Anyway, at the time that I drew it, I looked at all of this and mischievous me. Anyhow, next. Now, what have you written? I can't keep up with all your chat. Okay.
I make a question there.
Yeah.
If you look at the criminal code, actually, if you look at 100.14, it does say in that division, 1.1014A, a reference to any person or property is a reference to any person or property wherever situated within or outside Australia. And a reference to the public includes a reference to the public of a country other than Australia.
Really?
Yes. So that might suggest that perhaps beheading people in a country overseas would still run you foul of the code.
Yeah, no, it would. Good spotting. Good spotting, Desmond.
Sorry, Desmond, which one was it? Could I ask which?
Yes,
Which
it's the
provision?
Criminal Code 100.1 Part 4, immediately after the 3, with the things that disqualify you. Look at the bottom of page 175, I think it is.
Yeah.
Thank you.
Well, that's a good spot, because I mean, I hadn't read through this properly. So there you go. So the point that Desmond has made is, if you go to page 174, terrorist act, the action is done or the threat is made with the intention of, and I made the comment, which is ordinarily the case, that, you know, Australians can't legislate with respect to matters that occur extraterritorially, but I mean, obviously we have, and that's an interesting question, but you have to be intimidating the public or a section of the public. Public, I said, must refer to the Australian public, but subsection 4 says in this division, a reference, this is subsection 4B, a reference to the public includes a reference to the public of a country other than Australia. So, you know, the fact that they are beheading, you know, Iraqi Christians or something like that is sufficient to constitute a terrorist act in Australia. Is that right? Let's just work through the section again.
It seems that way.
Well, let's just read through it, because it seems bizarre to me. So a terrorist act means an action which falls within 2 and not 3, is done with a threat or intention of advancing a political, religious or ideological cause, and it's done with a threat that is made with the intention of intimidating the public. So you can be advancing a political, religious or ideological cause and intimidating a section of the public. So you can be, I mean, it's specifically designed to deal with ISIL, isn't it? Or anything. I mean, if an Australian was responsible for 9/11, for example, flying that plane into the Twin Towers, then you've committed a terrorist act in Australia as well, even though you did it on foreign soil. I suppose that's the nature of crime. And as Emma was saying, I think you just have to trust the agencies. I mean, I don't dissent from that view. I think that we do. I think that there's stuff that's going on out there that we don't know about for our own well-being, and we just have to trust in the agencies. And I mean, the fact that these provisions get bipartisan support all the time, thank you, darling, bipartisan support all the time suggests that they've all been briefed by the relevant agencies, and there are real issues that from which we need protection, and it's not this draconian legislation that the media drums it up to be. All right. Now, Peter Miles has written something as well, but I'll get to your thing. I'll get to your questions in a sec. I think it's just answered. So what are you saying, Osif? There is a list, ASIO terrorist organisation list, and Syrian army isn't a terrorist organisation. So you're saying there is another, I mean, because Australians would be, the Australian Armed Forces would be a terrorist organisation, because we're running around in Afghanistan, for example, you know, fighting Taliban, and that's political and that's religious, I suppose, to a very large extent. Is the Australian Army excluded? Which part are you referring to, Osif, in the ASIO Act? We probably have to have a look at the regulations. I might have to look at this. So would Australia fall within, would the Australian Armed Forces fall within this? Let's just have a look. Could you construe it so the Australian Armed Forces do? Terrorist act means an action or threat where the act is done or the threat is made with the intention of advancing a political, religious or ideological cause. I suppose you'd construe that fairly narrowly. I mean, the Australian Armed Forces aren't defending a political cause, they're defending, but they are, you see, this is an ideological war. This is a war about ideology. I mean, well, maybe we're not, maybe it's a national security thing. Maybe you'd construe that the Australian Armed Forces are acting in the interests of Australian national security.
Is this whether the Australian Armed Forces are conducting a terrorist act, or are they a terrorist organisation?
Well, what you do is I mean, they could be both, but
because I'd say
on.
under terrorist organisation, they'd be, yeah, okay, I see what you mean. So you started off by saying an organisation engaged in preparing, planning, assisting, fostering the doing of a terrorist act. And then you go to the definition of terrorist act and see whether or not they were pursuing that.
Yeah, and the point is the way in which you test legislation, the way in which you construe legislation is you test it, right? So you test it this way. And I mean, obviously, look, I'm sure someone thought about this, and there'll be regulations somewhere saying the Australian Armed Forces are not a terrorist organisation.
They would argue that they wouldn't be pursuing political, religious, or an ideological cause. They'd be doing it for the public good or
Exactly.
the security.
Look, the Australian Parliament did not intend the Australian Army, the Australian Armed Forces, to be a terrorist organisation. We know that. So this is part of your statutory construction process. We know that's the intention, because it's just would be such an absurd outcome. So you construe it this way. So let's construe, how do we use these words to exclude the Australian Army, right? Now, the Australian Army is doing something for an ideological cause, because we don't support our national security supports an ideology of liberal Western democracy as opposed to autocratic regimes, to further the spread of Islam. So that certainly, but an ideological cause couldn't be, it can't be an ideological cause supported by a state, I suppose, internationally recognised. I don't know. See, because the caliphate, what I'm getting at is the caliphate is a state as far as they're concerned. They're not recognised by anybody. And who recognised them? Does anyone remember?
Doesn't it have to have intention to harm with it? I mean, intention to harm the public, which obviously that wouldn't have.
Yeah, but the Australian Armed Forces are out there fighting the Taliban every day of the week. It's a section of the public. This is the point I'm driving at, is how do you construe this if you look at it through, if you test it that way? It's certainly the intention of the Australian Parliament not to capture the Australian Armed Forces. Anyway, I'll leave you with that food for thought. Write it down and think about it, because we'll have to come back to it, I suppose, in the tutorials this week. Definitely pursue it. Now, I'm going to keep moving through your questions. Definition of terrorist act isn't linked to a terrorist organisation. No, it isn't, but vice versa, Charlotte. So terrorist organisation incorporates terrorist act, and that's what I was getting at. But I think you're answering someone else's question, unless there's a security assessment issued by ASIO. What are you talking about, Orsef? Are you going to come on mic?
I think it was related to his comment above that, where he said there's a list of ASIO terrorist organisations and the Syrian army isn't a terrorist organisation.
But where's it coming from? Where does she say it comes from? Unless there is a security assessment issue by ASIO.
With regards to section 10, subsection 2B, where ASIO gives an assessment. Security assessment.
But that's a separate standalone ground. Like if ASIO's made an assessment, that's it. The prescription's lifted, and it no longer needs to be a reasonable suspicion reached by the minister.
That's right. You no longer need to prove within the criminal code the intention by the person.
No, I know that, but if the minister formed, obviously this is just going to be a means by which ASIO's findings are facilitated. I mean, that clearly, it is such a minefield otherwise for Dutton. I mean, for Dutton to have this opinion exercised on his own, and that's probably why none of this is going to go to any review authorities. No, because the review authority only is enlivened in circumstances where the minister makes a decision. All right, I'm going to move on. I think we need to look in the regulations and see if they have, and I'll do this for you, but you should do it yourselves. Have a look and see if there are some regulations or if the Act in and of itself excludes certain organisations from being terrorist organisations. You'd think there'd be a note, though, under the definition of terrorist organisation. Let's quickly have a look.
I'm just about to send it through, Bridie.
You found it?
Yeah, I did.
Good girl. All right. I'm going to come back to section 30, Cherie. I'm just reading through a lot of these, for those who are listening later, a lot of these questions, there's a lot of comments and a lot of chat going on, but I don't know that I need to read a lot of it out. Are sections 5 and 6 doing similar effect to the TEO Act too? What do you mean by that, Akio? Have you gone off to bath children in their swimwear? Or are you still here?
Sorry, I'm still here. My internet's kind of unstable. That one was about the one when the section that Desmond found.
Yeah.
You know, the
extraterritoriality provision.
Yeah, is it kind of the similar thing?
So 5 and 6 is carry on from that. Without limiting the generality of subsection 4, this part applies to the action or threat if the action affects or is carried out or would affect the interests of the Commonwealth, the authority of the Commonwealth.
No, sorry, the TEO Act 5 and 6.
Where it says Act extends to external territories.
Yeah.
Yeah, it's doing the same thing. I mean, they've made it perfectly plain because obviously, as someone mentioned earlier on in the tutorial, you know, the whole purpose of this is to stop someone re-entering Australia, which means they're outside of Australia. So this must have extraterritorial effect. But what I was remarking upon earlier is that the criminal code, which is a finding of guilt. I mean, we only punish our citizens or people on our soil, but this entitles us to effectively punish somebody who's not. And who's committing a crime not on Australian soil.
That was done, I think, as part of an agreement for child pornography or trying to stop, taking advantage of children overseas. I remember it was a case that came up by a particular person who was found guilty of soliciting sex with minors in Thailand.
So you're saying there's an international agreement with respect to extraterritorial prosecutions?
I believe there was. I remember doing this in criminal law, and I remember at the time that was the statement made, but I will admit that I never followed up to see if that was the case.
Yeah. I don't know that. It's interesting. I mean, I'll look into it and I'll put something up the Moodle about it. I mean, I have to admit, I have read the criminal code, but I have not examined it. But I'm asking you to do that, and I will obviously do that.
Just jumping in on that, I think we actually covered it in constitutional law in relation to the external affairs power. And I remember the case you're talking about in relation to the pornography in Thailand. That came up in constitutional law, I think.
Well, if anyone finds it, pop it on the Moodle, just for a benefit of our learning, all of us learning, so we're all smarter and harder and faster. All right. One of you two can do it, Desmond or Charlotte can do it. Charlotte's just rolling her eyes. It's you, Charlotte, isn't it? Yeah, that's Charlotte. Okay. Yes, Ben Robert Smith allegedly is under investigation for pushing someone off a cliff in Afghanistan. I think it's all terrible. I don't think we should be examining the way that people behave in war. Anyway, I mean, it's hardly the Holocaust, but look, I don't know. We'll see. It's just, Yeah, it's the dismal state of affairs in which we find ourselves. There is a list of terrorist organisations created by ASIO. You're going to find it. Someone's put it up. Yes, good. But look, I don't think Emma has put it up in the chat, and I'll stick this up on the Moodle as well for you. Now, moving on, I've got to do section 30 before we finish. It wouldn't be to exclude Islam, it would be exclude terrorist acts of any individual, not because they are Muslim, but because ISIS commit terrorist acts. Who said that, Margaret? Yeah, maybe. An individual can commit a terrorist act regardless of whether or not they're in the Australian Army or not. Yeah, but I'm looking at terrorist organisation. I don't think that the national security listed terrorist organisations can in any way affect terrorist organisation for the purpose of the criminal code. I think the criminal code is to be construed according to its context. So whatever the Australian government defines as a listed terrorist organisation is irrelevant unless the criminal code, somewhere in its regulations or in its provisions itself, says these are an exhaustive list of terrorist organisations. I don't know. We've got to look at it more. 51 Defence Act 1903, protecting Commonwealth interest against domestic violence. Who said that, Emma? Why are you saying that?
Oh, that was back when you were talking about how the Army would not be, or the Navy, or whichever defence force you're talking about, going into other countries to protect the Commonwealth. Are they committing a terrorist act? Well, they're protected by Defence and Commonwealth.
Yeah, but I mean, we know that the legislative intention is not to capture the Australian Army. So that's the way you would construe these provisions so as not to capture it. That's the point I'm making.
Yeah, that was the Lego block that goes in together with this act. So you use the Defence Force and all other acts as Lego blocks with this act to what you're saying, so that they're not caught in that.
Yeah, so the way in which you approach the task of statutory interpretation is you test it and you say, look, we know the intention of the legislature was not to include the Australian Army, so how then do we construe these provisions so that they're not caught? And then that construction would apply. So, that's how you imply intention. Rather than looking at, what was their intention? They want to catch ISIS. Well, they don't want to catch just ISIS. That, you construe it by what we know they don't want to capture. And then they want to, they want to pretty much stop terrorists all over the world. I mean, and they may not necessarily just be sitting in ISIS. They'll be sitting in Afghanistan. They might be sitting in Lebanon. They might be sitting in God knows where else. I mean, everywhere. They might be sitting in Tasmania, or maybe not Tasmania, but maybe New Zealand. All right, now I'm just going to keep reading through your questions. Isn't there a world ideology which Australia is part of, the war on terror? Yeah, that's what I'm talking about, Russell. Islamophobia. I don't know that it's Islamophobia. I think it's just we haven't got over the Crusades. We just have not got over the Crusades. I mean, it's a bizarre. Don't even get me started talking about this stuff. But this is more political than it is law. Otherwise, we wouldn't have Muslims in Australia and allow mosques to be built. What are you guys going off on tangents for? I'm not reading out half of these.
I can answer that question if you wanted to about do it quickly, XYZ versus the Commonwealth.
Yeah.
It was, the Crimes Act made it a offence for an Australian citizen to engage in sexual intercourse with a person under 16. Whilst outside Australia, the applicant got charged and argued the external affairs power only extended to the making of laws with respect to relations between Australia and other countries. And the majority held that the modern doctrine of the geographic externality principle meant that the law included powers to make laws with respect to places, persons, matters or things outside Australia's geographical limits. And they applied Polyukovich versus the Commonwealth. And Charlotte was right, it was in constitutional law.
You can ignore the rest of the chat because Charlotte and I posted up a link to it and citation and everything. You're right.
Sorry.
You're right.
I should be reading too.
That was a great summary.
No, that's great. Thank you, guys. I mean, that's well past my time at law school, but That's why, you know it, and I wasn't, I mean, the law prior to that was, I mean, I know about Polyukovich, that's back in my time, but I mean, I just haven't come across this since. Thank you for that. All right. Now, I think I've got through all your questions. Let's have a quick look at section 30. Someone asked, can we dumb it down? I don't know if I'm able to dumb it down. I'll do my best. So severability, there was a lot of hoo-ha at the time when this law was made. You know, there's a lot of debate, and you should go and have a look at the digest and at the debates before the prorogation and then after. So when this legislation was introduced in a February sitting, they debated it a fair few times, and then the election was called. And the election being called meant that, you know, everybody, once the writs are issued, which whenever that was, I think it was April, early April, once those writs were issued, there was no parliament anymore, and the government was in caretaker mode. So there was some debate at that time about it, and one of the issues was that this was unconstitutional. And I've expressed my view several times on why I don't think it's unconstitutional, because it's an exercise of administrative power. It doesn't purport to exclude judicial review. We can make laws with respect to the movement of Australian citizens in and out of Australia as much as we like. We can do that. That's not a problem. It is we can completely deny someone procedural fairness. We can do all the things that this Act purports to do, but they nonetheless had some, that I think it resided around that the minister would form a reasonable suspicion with respect to an offence, and that they were effectively finding somebody guilty of the offence. And I don't think that's right. I think it's akin to police powers, that a policeman every day of the week, when they arrest you pursuant to whatever arrest power they're exercising under whichever state you're in, they just have to form a reasonable suspicion that you have murdered someone, okay? And it needs to be on the basis of, you know, more than a mere hunch. The suspicion has to have some grounding. They have to reasonably suspect. So reasonableness is the relevant prism through which you look at their suspicion, but as I've said many, many times, it's a matter about which reasonable minds may differ. But as long as it has intelligible justification, then you're away. The Parliament was cognizant of the fact that immediately after a TO order is made, it goes off to a reviewing authority, and the reviewing authority looks over it for specific errors, and that's it. And if they're satisfied that none of those errors exist, it's a valid TEO. If they are satisfied that one of those errors exist, the decision was never made. Okay, so the TEO never came into effect. It's void ab initio. That is a necessary. We'll query whether or not it is. Is it a necessary step in the validity of a TEO? So the language of the section is immediately after they must send it off, and then it's reviewed. But all that happens is it can be rendered nullified, but it's in effect the whole time that it's being reviewed. And I'm trying to figure out in my mind what that does to the TEO. Is it a necessary step? Can they stuff it up? So say, for example, there's a mistake made along the way in the review process. Will that invalidate the TEO? That's something you've got to look at and think about. But one of the matters that would inform how you look at that is because they say it's not essential. It can be severed and the Act can go on as though 14 had never been enacted. So I'm reading directly from section 30, subsection A. It's Parliament's intention that this Act operate as if, you know, section 14 had never been enacted. So if somebody challenges section 14 on the basis that it's not a valid law of the Commonwealth, I don't know what basis they'd challenge it, because I think it seems to me to be valid. You know, it doesn't engage the persona designata issue. It doesn't, it's just a form of administrative review. You know, it's on very, you know, there's, Parliament can legislate to the extent to which review takes place. They can create a statutory review in the same way that they can create a statutory appeal that can be limited to just questions of certain law or questions of error of law. There's nothing wrong with that. But obviously, and even a reviewing authority, because it's an administrative act, they can deny everybody procedural fairness as well. But obviously they harbour some, I suppose, apprehension that it might be severed. The fact, though, that they've enacted a severability provision, what does that mean for the essential nature of the review? Is it inessential, or is it? I'd say it's essential, but I don't think it's a necessary condition upon which the minister's power is to be exercised. And this is your task. You're going to have to figure out whether or not a review is essential. So say there's an error in the review. Say there is palpably an error of law on the face of a decision and it's not picked up by the review authority. Does that, does the fact that the review authority not pick it up invalidate the TEO? That's a question that you need to ask.
Can I ask a thing there? You expressed a concern about the order of events being that they have to, as soon as possible, notify the person, but they also have to put it in for review. I don't think there's a conflict there because of the language. I think if you look at section 10, well, look at section 14, sorry, that says, let me just scroll to it since I've said this. That says, because you asked the question, what does immediately really mean? It says immediately after making, the minister must refer the decision to the reviewing authority. That's fine. So I see that as the step you do before you notify the person. Because if you go back and look at 10 and 10, is it 10.2? That says the minister, is it 10.2? Can do it as soon as reasonably possible. Sorry, 10.8, that is, 10.8.
Yeah.
Look at 10.8, it says the minister, as soon as practical after a temporary exclusion order comes into force. So I think the actual, I tried to draw a flowchart of what was going on, and I think the first thing you do is you do section 10.1, because those are the 4 things that have to enliven the power, and then for which you'd have to consider 10.2. But then the next thing you do is you throw it over to the review panel, and then once they say yay, then you say, okay, let's notify the person, so you don't fall into that trap, because you've got that may versus, you know, as soon as possible distinction.
I don't think that's right. I don't think that's right. I mean, you might be right if you can justify. I mean, as I say, you don't have to agree with me. You can, as long as you can explain to me why you think what you think, Desmond, that's fine, and you get all the marks, right? Because, I mean, I'm not precious about it every day of my life. Somebody doesn't agree with me. That's my whole job. You know, I'm always in an adversarial situation. But I think that this is a standalone requirement. As soon as reasonably practicable, and you read the word reasonably in, there's a number of cases that say you read the word reasonably into that phrase as soon as practicable. I mean, one of them is Webb and the Queen, and there's a couple of others subsequent to it. I mean, if you really want to read them, I can put them up on the Moodle. It's not that big a deal, but you construe it in the context of this act. What is reasonable practicability? And I think the reasonable practicability addresses the fact that somebody is overseas, they're probably living in this Syrian refugee camp or something like that, and you know, or they may not. They may be off grid or something like that. But we know them to be this terrorist threat, and we don't want them to come back. So as soon as practicable, after it's made, the minister must cause such steps to be taken as are, in the opinion of the minister, reasonable and practicable to bring to the attention of the person the content of the order. And it's a funny provision, because just say this person never gets notice of it. they have to take whatever steps, in their opinion, reasonable and practicable to bring it to the attention of the person. So they don't have to serve it on them. They just have to do whatever they think is reasonable and practicable to bring it to their attention. So email it to them, put an ad in the paper, stick it up on Facebook, what is it? But I think it's nonetheless, I think it's a standalone requirement. And then immediately after it goes through reviewing authority. You can't limit, I don't think section 14 would factor into the practicability of what subsection 8 is talking about, because there's no real time limit on when the reviewing authority is to make the decision. Again, they just must as soon as reasonably practicable. What is reasonable practicability for the reviewing authority?
Well, it says in subsection 6 that it's also got to be without the affected person having been notified of the review. So it does have to be in reasonable time, or they're going to be sitting there waiting for an outcome, or not.
No, but the thing is they will, this is what I was saying to you, hunt about. I don't think they have properly excluded procedural fairness here, because these people are going to be on notice of the fact that TO order has been made against them, I reckon, by the time the reviewing authority gets to it, potentially. And the reviewing authority must conduct a review in the absence of the person without the affected person having been notified of the review and without the affected person having been given an opportunity to make any representations. So they're excluding the fact that they need to be notified of the review. They're excluding them from a hearing, so it's to be determined in their absence, and they can't make any representations. But I mean, what other aspects of procedural fairness would subsist? Have they covered the bases?
Righty, I had a similar, my question to you was exactly the same as what Desmond has articulated. And it's almost like an ask about face provision, because if they haven't been notified, or they have been notified and they haven't made that reviewing decision, once that reviewing decision comes out, possibly in their favor, the outcome of that is that the TO order has never been made at all.
But it can be made again, you see.
But then the government served its purpose by delaying, like time wasting, haven't they? So the minister could have made the decision, whether using his discretion, and then this can be used as a time waster. Let's sit with the reviewing authority for a while.
Yeah, I don't know. I'm not going to be so cynical about it. I mean, I think that this whole thing will come undone because this is so scrutinised, and there is specifically an annual accountability to Parliament. I think they've got to keep their noses clean. So I don't think they're going to abuse it. If they do, they'll come under such crossfire. I mean, I can just imagine Dreyfus getting up and carrying on like a pork chop, but even though he's completely in support of this. I mean, they sort of lightly debated it, and then they all went and sat on the right-hand side of the chamber. It was only the crossbench who sat there like, you know, the five blind mice. But anyway, the issue that I'm trying to get you to think about is this structure creates a circumstance where people are going to be on notice, right? Now, assume the reviewing authority decides that there was no decision at all and it's nullified, okay? This person is going to potentially be on notice of the fact that a TO decision has been made about them. Then the minister can make another, because as I think you've seen, in subsection 9, is it in 10? Where is it? Let me find it. They can make another one. Where's that provision? Not subsection.
Subsection 9 in 14, is it? As soon as reasonably practicable after completing a review, the reviewing authority must return to the minister? No,
it's 7. Section 6D does not prevent the making of another exclusion order in relation to the same person. So paragraph 6D says, specify the period during which the order is to be enforced, which must not end more than 2 years after the day on which the order is made. Okay, so you can make another one after the second year. So you can keep them out effectively for the rest of their life if you like, if they continue to engage in terrorist acts, etc. But isn't there a provision somewhere where it says that this doesn't stop the minister from making another decision, or is 14 the end of it?
It's 11.6.
1410, Daddy.
Yeah, it's
11.6.
11.6. It's 11.6 and then 14.10. Is that right? Okay, so
They
I
say
knew.
it a few times.
Yeah, it is. It's 11.6 and then what does 14.10 say? Yeah. All right. So the point is, yes, I was right. I was doubting myself for a second. The point is, say Murray Gleeson comes in and very shrewdly says, no, you've made a mistake here, Pete, and it's nullified. This person's probably on notice that a TEO order's been made against them. So they know that a TEO order's been, that the intention is to make a TEO order against them. So if you have a look then at the wording of 26, which is your procedural fairness provision, remember, Kiowa and West, all these cases, they say procedural fairness applies and you construe it very narrowly when they purport to exclude it. So the minister is not required to observe any requirements of procedural fairness in exercising a power or performing a function under this Act. Okay, now, does that work in circumstances where somebody's on notice?
Probably not, because they've had a duty to provide notice to them, which is a
but
basic element of procedural fairness.
I know, but the thing is that they're on notice of the order having been made, so it's subsequent. See, procedural fairness applies to the process, but say it's nullified. My food for thought for you is this: an order's made, goes to Murray Gleeson. Murray Gleeson says, "You've made a mistake, Peter. It's nullified." In the meantime, they've got on to old mate in the Syrian refugee camp. He's picked it up on his Facebook or whatever, and they are able to, they're on notice of the fact that a TE order has been made. If the fact that they know that the government is inclined to make this order against them, does that enliven any procedural fairness requirements? Because the whole basis upon which, remember in all these cases, they've said in circumstances where they purport to oust procedural fairness entirely, there nonetheless can be remnants along the way which suggest that they didn't oust it completely. So aspects of it survive. So in MIA, for example, where they purport to say this is an exhaustive statement of procedural fairness, what does that have to say on provisions like this? Does it succeed? Have they succeeded in completely excluding procedural fairness? You really need to think about that. Okay, because
is there no argument to say that, I mean, I know it's not a judicial decision, but once it's being referred or it's been referred by the minister immediately, is there no argument that that suspends the enforcement of the order, that it's now not final yet because it's under review? So our thinking that once the person gets notice of it, it is then final because the reviewing authority has made a decision. So that referral...
I don't think so. I don't think so, because I think it's voidable. There's a difference between voidable and void. The decision is voidable. By virtue of the reviewing authority's power, it's a voidable decision, but it's effective until it's voided.
Okay. So we're incorrect in assuming that because there's provision of immediate referral, that it then has been reviewed already once it's gotten to the notice to the person. So it's effective until reviewed.
Yeah, I think, yes, you're incorrect is my answer. I think that the order is made, it's voidable by virtue of Section 14. So Section 14 creates a circumstance where it can be completely nullified and voided ab initio, but it's effective until such time as that occurs.
But then that brings up all questions
Friday.
of prejudice.
Yeah, sorry, we've got Charlotte and Nikki. Yes, Charlotte, you asked something.
I was going to say that's not my interpretation of it, because it says that the order only comes into force after the reviewing authority's decision is made.
Where is that?
And that's in the notes in Section 14.
Which notes? If the
So
review saying note, if the reviewing authority decides that none of the subparagraphs apply and the order is not already come into force under 13.1b, the temporary exclusion order comes into force immediately after. So you've got to go and look at 13.1b.
that's in relation to whether someone's already been determined under ASIO. Oh no, that's in the immediate urgent circumstances, sorry.
A temporary exclusion
That's because
order.
of urgent circumstances.
Yeah.
Let me follow it through. Hang on.
I think I have the similar note too. There's no decision until the review's done. It has been mentioned somewhere, but I can't find it either.
Yeah, it might have been me mentioning it, and now I'm confusing myself and tying myself in knots. I've got to have it printed out. I've got it printed out at work. I just haven't printed it out here. Hang on.
But are we saying there's a difference between decision and order? Because in 14.1 it says that they make the order first and then he refers the decision.
Yeah. Yeah, all of this stuff is relevant because the words are there for a specific purpose. They're not there for, they're not just there by accident. You construe each word to have meaning. So let me just pick up on these words that you're referring to. Order, order, order.
It's 14 subsection 7. So it's when the TEO decision has been reviewed, then the person must be notified of the review, which reads to me that the order is in place until it's reviewed and then you notify them yet again.
No, but the review is different. The review is a different creature. Let's have a look at 13. Period for which a temporary exclusion order is in force. A temporary exclusion order in relation to a person comes into force if subsection 2 does not apply immediately after a reviewing authority makes a decision under 14 that none of subparagraphs blah, blah, blah. Okay, so it doesn't come into force until the review. And then if subsection 2 applies immediately after the minister makes a temporary exclusion order. 2, this subsection applies if the minister is satisfied because of urgent circumstances it's necessary for a temporary exclusion order in relation to come into force immediately after it is made. Oh, shit. Right, so unless the minister forms that relevant opinion for the purposes of section 13, you're right, the review is an essential step, which casts a different light on the review because the review is a necessary indice of the order's effect.
Yes, because that's mandatory before it can even come into effect. That's why I thought that once the person gets notice, they've already reviewed.
Yeah. So what does that say about the review then? What does that make the review? I don't know the answer to this. You've all got to think about it. I will form the view, but I won't mark you down for having a different one. Obviously, we're going to be talking about this more in the lectures. I'll give some more thought to it, and I'll give you another lecture on it. Ask the relevant questions. But 14 to me has always been, in my mind, an inessential step. And I can't remember why I formed that view because obviously I looked at this a little while ago and then I've come back to it in order to prepare for the exam with you. A temporary exclusion order in relation to I'm just looking at the language now, so I'm engaging in this process of statutory construction that I'm going to ask you to do. A temporary exclusion order in relation to a person comes into force immediately after the reviewing authority makes a decision. Okay. Now, that decision, it's just a decision, do we impute to that decision a lawful decision? Like, must that be lawful? That it only comes into effect if the reviewing decision is lawful? So does that mean that in judicial review terms, what is being reviewed is the review decision as well? So on for judicial review, do they need to review the minister's decision and the reviewing decision to see if the two pieces of the Lego bricks fit together? Is 14 a jurisdictional fact? No, I don't know. Oh, I don't know. How exciting for you. What an exciting exam.
It
You
makes
could
it
argue this is not an inferior court or anything. I mean, not a superior court, definitely.
No, it's
not an inferior court even. So therefore, under the other cases, the decision isn't valid. I mean, it can be void ab initio, can't it?
Yeah, exactly. But the thing is, it's a necessary step. It doesn't come into force. It doesn't operate against somebody until this review decision is made. That's why the severability provision is so enticing, because it demonstrates a parliamentary intention that if it's invalidated, right, a temporary exclusion order will still be made. But have they cured this issue in 13? Wow, they've rushed this.
Decide if he doesn't want to, if it's urgent, he can just make it in force immediately.
Yeah, which is probably what he's going to do to avoid all of this crap. But he has to be satisfied of urgent circumstances, and those urgent circumstances would be reviewable on the basis of reasonableness.
Yeah.
Okay, well, I'm going to give some thought to section 14 and 30 and all the things that we've discussed today. Send me your questions, all right? Because it's 5:30, guys, and you probably all have evening responsibilities. I'm just going to quickly read through your questions, but write down lots of notes and thoughts and then stick it all up on the Moodle, all right? Because we need to work through this. The review is a necessary step, the provision of procedural fairness for a person who cannot have Margaret. I don't know, procedural fairness is a feature in the exam. You've just got to think about it. Peter Miles said 10.8, yes. Does section 14 give the review panel too much power, meaning it's potentially ultra vires? I mean, I think so. Now that I'm looking at, only in circumstances where the minister doesn't think it's urgent, then 14 is relevant. But you see, the review authority, look at what's happening here in 13. 13 says it doesn't come into effect until the review's over and done with. 13 subsection 2 says if the minister thinks it's urgent, it comes into effect straight away. But that doesn't mean that 14 doesn't take place. 14 takes place nonetheless, and it can be nullified. The two have to work harmoniously together, those two circumstances. So the order coming into effect after the review and the urgency situation taking place. The two have to work harmoniously together, and no matter what. So that has the effect that when you understand that, that has an effect for section 14. Is it an essential step? Because it can be overridden by virtue in circumstances of urgency, that would tend to undermine it being an essential step. So from a Project Blue Sky perspective, if they stuff up in the review, does that mean that the review decision becomes the subject of judicial review, right? And I think my intuition says no. The intention is you review the order, okay? Because it doesn't do anything. Like the AAT, for example, they deliver what's called the correct and preferable decision. That's a form of administrative review. So the decision which is the subject of scrutiny on judicial review is not the original decision, but the decision of the review authority. My intuition here, just my sort of statutory interpretation intuition, is that I don't think the intention of the legislature was that you review the review decision, because it's too limited. It's not a review de novo. They're not arriving at the correct and preferable decision. They're not substituting their decision for that of the minister. All they're doing is, to use the parlance of the day at the moment, they're just fact checking it. They're just law checking it. They're checking it to make sure that it doesn't contain an error of law. You wouldn't review that decision. You'd review the minister's decision on all grounds, I would have thought. But because it is a necessary indice in the decision coming into effect, the order coming into effect, query whether or not I'm right on that. I still think I'm right on it because all that has to happen, and someone said this, is this a jurisdictional fact? It is. It is a jurisdictional fact in the sense that it's not a jurisdictional fact, but it's a necessary step in the decision-making process, in the order coming into force, that a review has taken place. It doesn't have to be a correct decision. It just has to be a decision. And but then what I think Desmond said when he came on mic is oh, well, it's an administrative decision, so it's not lawful unless it doesn't have an inherent force as would happen with a court of superior record. So, you know, a decision made by a superior court is within jurisdiction, whereas the reviewing decision can be made without jurisdiction. They can fall into error themselves, such that that decision is not immune. So query whether or not an error in the review process is capable of invalidating the order. Think about that. All right, I'm just going to have a quick read through your last questions and I'm going to go and make the nachos. I want that too, nachos. Second time, yeah, I always do nachos, so easy, they love it. All right, have any orders been made? No, I don't think so. I don't know. Possibly. I can imagine they've got people lined up ready to make orders. Anyway, look, this has probably been more confusing than it has been helpful, but at least it's started getting your juices flowing. Does anybody have any last questions before I sign off? Is there anyone left? Still 22 of you. Hopefully you've thought about some stuff. No, I'll do a Sunday tutorial next week.
Friday, sorry.
Yeah.
Is it an hour earlier?
Pardon?
Next Sunday, an hour earlier then, or not?
For you, yes.
Okay. So
For us, our clocks will just move. It's torture. I'm supposed to be going to a 50th down in Adelaide next Sunday. I haven't booked my flight to go because I can't find anyone to mind the 5 children. We haven't got all 7 of them. We've only got 5. So if anyone wants to volunteer, but no. Yeah, I think it'll be on. But if I do decide to go, I might move it to the Monday because it's a long weekend here. And I'll make it at a time convenient to you, Nikki and Charlotte and people like that who are over in the Northern Hemisphere. Yeah, think tank time. Go and get on your Facebook page and start bitching about how much I've confused you. Knock yourself out with that. We will discuss section 26 next week. I want you to stick stuff up on the Moodle, okay? I want you to start ruminating over all of this and put it up on the Moodle. And I can endeavour to answer the questions sort of slowly and with pause for thought, because at the moment you can see my little brain, or you can potentially hear my little brain ticking over. I need to print this section out and really work through it myself and come to a firm view. Anyway, all right. You want Monday? Who wants Monday? Do you want Sunday or Monday next week? Monday for... You write Tuesday property. Sunday, Sunday, Sunday. You haven't... Okay, Sunday. I'll make it Sunday. I can make it another time. I can make it on Saturday. That's just a crime against humanity. It's a crime against humanity on a Sunday on a long weekend as
You'll
well.
be in Adelaide. Keep it on Sunday.
No, it won't be on Sunday, on Saturday. It's on Sunday. It's on the 6th. It's one of my best friends. She's turning 50. It's the Rugby League Grand Final on Sunday. It is too. Saturday. Why don't we make it Saturday? All right. I might move it to Saturday. Just I'll put a vote up on the Moodle for everyone to vote.
What if we just do the Thursday one that we always do as a...
Yeah, but not everyone can make that. But you know, that Saturday would work better for you, Nikki, because unless you've got commitments, because time moves over on Sunday morning at 2 o'clock. So Saturday night.
Yeah, I'll just fit in with anyone else.
Then you won't be in your PJs.
I'm currently in my PJs.
All right. Okay, I think I'll move it to Saturday for that reason. I don't want to clash with the grand final. It allows me to go down to Adelaide if I need to. And you work on Saturday, Margaret?
I think that was about the Thursday.
All right, yeah. Yeah, I'll move it to Saturday. I'll move it to Saturday, kids. And I'll make it like 4 o'clock or something. I'll probably be drunk because I like to have a wine on Saturday. But anyway. All right, you can all have your wine. We'll just construe the TO act smashed. That'd be hilarious. Okay, I'm going. Thank you. Bye.